This bill is about granting immunity for crimes to criminals that the government employs. I have 5 issues I want to raise today, but I'm sure there'll be more in the future. I want to start by highlighting that many victims of undercover policing are currently finally giving evidence to the undercover policing inquiry. It is exploring systematic abuses by undercover policing units over a period of 40 years. It's therefore regrettable that the government is bringing this piece of legislation before any lessons have been learned. More indeed can be learned from the public inquiry. So will the Minister undertake to bring further legislation in the future to deal with any recommendations that come out of the inquiry? Secondly, I want to dispel any notion that this legislation is simply regularising and codifying the existing status quo. This is simply not true. Most significantly, there is currently no blanket immunity granted to undercover state operatives. There are legal defences which can be relied on, and prosecutors can and do decide that it isn't in the public interest to prosecute undercover operatives. But this legislation actually seeks to replace that with a blanket system of legal immunity, which will be self-administered by the agencies themselves. And this undermines victims' rights and gives them no legal redress when they're harmed by undercover operatives. Thirdly, there are no limits on the face of this bill to the criminality that can be authorised. So the government's response is that the Human Rights Act will prevent these types of crime. But even if that's true, it remains this government's stated intention to repeal the Human Rights Act. So can the Minister please be very clear about what the government's proposals are to change the Human Rights Act and how this will interact with the bill? The bill allows the Secretary of State to, by regulations, place limits on what conduct can be authorised. So the government has already explicitly conceded in the drafting of this legislation that there is a need to put restrictions on what can be authorised. The Joint Commission on Human Rights said it best at paragraph 42 of their report on this bill. The government should not introduce unclear and ambiguous laws that would, on their face, purport to authorise state-sanctioned criminality that would lead to serious human rights violations, such as murder, sexual offences, and serious bodily harm. You can see that we have a problem here, my lords. Now, one doesn't have to be a human rights lawyer to realise that the government is not allowed to authorise people to commit such grievous crimes. Parliament should place limits on the face of the bill. In particular, we must prohibit the use of government agents as agents provocateurs who infiltrate legitimate political campaign or trade union groups and disrupt their activities or cause them to commit criminal acts. On the issue of child spies, which I've spoken on many times, I think this is dangerous, it's unethical, it's cruel, and I would prohibit it. Fifthly, I'm very concerned about the overlaps of this bill with things that are already existing legal processes. For example, the risk that authorisation under this bill could bypass some of the legal safeguards like search warrants or phone tapping authorisation, or authorising conduct that interferes with legal processes such as tampering with evidence, contempt of court, or perjury, that could all be argued to be necessary and proportionate. I look forward to working with other noble lords across the House to significantly amend this legislation. I believe that if we can't amend it significantly, then it must be voted against in its entirety.